Hello, and welcome to the National Right to Work Foundation's news update. In Wisconsin, a state court struck down monopoly bargaining agreements between the Kenosha Unified School District and 3 local unions as illegal under Wisconsin's Act 10. Current Kenosha teacher Carrie Ann Glembocki and former Kenosha teacher Kristi LaCroix filed the lawsuit with free legal assistance from the National Right to Work Foundation and the Wisconsin Institute for Law and Liberty. The lawsuit challenged agreements between the district and officials from Kenosha Education Association, SEIU Local 168, and AFSCME Local 2383 that required teachers and other staff to pay union dues or fees to keep their jobs. After passage of Act 10 in 2011, most Wisconsin public sector employees cannot be forced to join or pay union dues as a condition of employment. Despite the law, the Kenosha School Board approved the 3 bargaining agreements, which contain provisions allowing union officials to collect union dues from all district employees, including non-members. The Wisconsin State Court's ruling holds that Kenosha public school employees cannot be forced to pay union dues or fees to obtain or keep a job, as that is in violation of Act 10. In Washington State, SEIU Union Local 925 officials sent a letter to family child care providers dropping their forced dues demands the day after a group of family child care providers filed a federal class action lawsuit challenging a 2006 law authorizing the forcible unionization of Washington State's 12,000 home-based child care providers. Cindy Mantell and 3 other providers filed the federal class action lawsuit with free legal aid from National Right to Work Foundation attorneys in conjunction with the Freedom Foundation. The Washington Child Care Providers lawsuit challenges the forced unionism scheme on the ground that it violates the United States Constitution's guarantees of free political expression and association. National Right to Work Foundation attorneys argue that such schemes violate the child care providers' First Amendment right to choose with whom they associate to petition the government, because the government does not have the constitutional authority to force citizens to accept its hand-picked political representative to lobby itself. Last year, the United States Supreme Court issued a landmark ruling in Harris v. Quinn, argued by a National Right to Work Foundation attorney, holding that individuals who receive state subsidies based on their clientele cannot be forced to pay compulsory union fees. The Supreme Court did not rule on whether providers can be forced to accept the union's so-called representation under a monopoly bargaining scheme. The Washington child care providers also seek repayment of union fees illegally taken from them by the governor and given to SEIU Local 925 over the past 3 years. Thank you for tuning in, and see you next week.